branches of government. And of course, it's a central issue about the ability of the judiciary to carry out its functions as the defenders, the protectors, and promoters of human rights and the rule of law. So the ICJ is unique in many ways in that it's an NGO, it's a human rights NGO that has the privilege of counting among its commissioners several people who are either sitting judges or former judges, and are able to speak about this issue directly, and are able to engage our other colleagues in the legal community, academics, working lawyers, political scientists, to discuss what should be the limits of free expression for judges and members of the judicial branch. I'm also very, very pleased that, as you can see, that this discussion is based out of the ICJ's Africa program. This has been part of the ICJ's efforts over the last few years to ensure that its operations are not just reflecting one region of the world, frankly, not that of the Northern Hemisphere, or even more accurately, Western Europe and North America. Although I'm based in Geneva and that's our headquarters, we've tried successfully to make sure that many of our central functions, for instance, looking at the independence of judges and lawyers and the Center for the Independence of Judges and Lawyers, are spread around the world, to make sure that international law and discussions around global rule of law are fully incorporated and implemented within the Africa region, but maybe even more important, that the views and experiences of different regions of the world, of practitioners from different parts of the world, are reflected in the development and the implementation of international law around the world. And I'm very proud that the ICJ has been able to do that. And I'm very pleased that for the past year, our colleague, Justice Mavedzenge, has taken over the mandate of the independence of the Center for the Independence of Judges and Lawyers. As Justice himself says, he was born named ready for this job. So I'm very pleased that he is now able to take over this very important and central responsibility for us, along with other colleagues in the Africa program. So I really look forward to this discussion. I want to thank our several of our commissioners and friends who are here from all over the world. I think I'm not sure where Imrana Jalal is. I'm guessing somewhere far east, and Cesar Landa, I think, is in Peru. So I think we're straddling the world, and it's a reflection of the global reach and diversity of the ICJ, which I'm very very proud of, I think. So with having said that, let me hand over to the people who are going to run the show, to my colleague Kajal Ramjitankyo, who's the director of our Africa program, and then to Justice Mavedzenge. Thank you very much, commissioners, friends, colleagues, and I really look forward to hearing this interesting discussion. And I just want you to know that it'll be the first of many other similar discussions that we hope to have with colleagues from around the world. So this is a great first step. Thank you very much.
Good afternoon, everybody, and good morning, depending on where you're joining us from. We will start this afternoon with the first presentation by Dr. Justice Mavedzenge. Justice is with the ICJ. He is the global coordinator of ICJ's Center for the Independence of Judges and Lawyers. Prior to joining the ICJ, Justice was with the Democratic Governance and Rights Unit at the University of Cape Town, and he also lectured constitutional law at the University of Cape Town. Justice will this afternoon be speaking to us about the regional and international norms and standards on freedom of expression for judicial officers. Justice, over to you.
Sorry, I was reaching out for my electronic mouth. Thanks very much, Kajo, for such a wonderful introduction. I don't know if I deserve it. The only thing I can add is that on this panel is my former supervisor, Pierre De Vos. And maybe I should say, if I say the wrong things here, blame Pierre. Okay, so let me just quickly, before I do that, Kajo, can you hear me? Am I clear?
We hear you very well, Justice.
Fantastic. So I am going this afternoon to basically talk about the applicable international norms and standards on this very important question of freedom of expression for judges. And I'm going to try and do that in 20 minutes, so which means I will have to summarize a lot of things and perhaps provide more details when asked during the question and answer session. So the way I want to deliver my presentation this afternoon is to start with outlining the International Commission of Jurists' efforts and policy position on freedom of expression for judges, because this is a subject that ICJ has been working on for quite a long time. And in so doing, I will set out and make reference to the applicable key international legal instruments. So in 2019, ICJ made some submissions to the United Nations Special Rapporteur on the independence of judges and lawyers, Mr. Diego Garcia Sayan, for his consideration as he was preparing his report to the Human Rights Council of the United Nations. The ICJ, in its submissions, drew from international and regional instruments applicable on this subject. So at the international level, I think it's important to highlight that the key instruments and conventions which protect the freedom of expression for everyone, including judges, the Universal Declaration of Rights and the International Covenant on Civil and Political Rights. And then at the regional level, the applicable key ones include the African Charter on Human and People's Rights here in Africa, the European Convention on Human Rights in Europe, and the American Convention on Human Rights. And these are the key regions where the ICJ is currently working in. Now, in addition to these, there are a number of non-treaty standards which address issues of freedom of expression, specifically for judges. So I'll just highlight a few of the key ones drawn from the different regions where ICJ works. So globally, we have the United Nations Basic Principles on the Independence of the Judiciary. We have the United Nations guidelines on the role of prosecutors, the principles and guidelines on the right to a fair trial and legal assistance in Africa, which was published by the African Commission on Human and People's Rights in 2005. Then we have the Beijing Statement of Principles on the Independence of the Judiciary, which was adopted by the Chief Justices of Asia and the Pacific way back in 1997. Then we have the Council of Europe recommendation on judges, independence, efficiency, and responsibilities. And it is also important to note that we have the Declaration of Principles on Freedom of Expression adopted by the Inter-American Commission. Now, based on these conventions and instruments, as well as the ICJ's global experience with states and judiciaries from around the world over some 6 decades now, the ICJ is of the view that, number one, judges are like other citizens and they are entitled to freedom of expression, belief, association, and assembly. Number two is that any limitation on the exercise of these rights by judges and prosecutors must be subject to the general criteria under international law for such restrictions, including as regards necessity and proportionality. And given the fundamental importance of the independence of the judiciary for the right to fair trial, effective remedy for human rights violations, and the rule of law more generally. Any restrictions on the exercise of these freedoms that are specifically related, and I think I want to underline that are specifically related, restrictions that are specifically related to judicial functions should be established by the judiciary itself or another independent body with majority membership of judges. Then number 4 is that proceedings against a judge or prosecutor that are related to their exercise of these freedoms, including allegations that they violated validly imposed restrictions, should comply fully with international human rights law and standards in terms of the grounds and procedures used. Then number 5 is that the judiciary plays a special role as an organ of the state that is subject to requirements of impartiality and independence. And in order to they enjoy this in order to respect and protect, amongst other things, the human rights of other people. And consequently, restrictions to the exercise of these freedoms that are demonstrably necessary and appropriate to guarantee their impartiality and independence can, in principle, be justified. Then exercise of these freedoms can lead to a requirement to recuse oneself, regardless of whether the activity occurred in the judge's public, professional, or private life. As such, judges should consider in all their activities the possible future consequences and perceptions likely to arise from their exercise of these freedoms, and should seek to minimize the situations in which they may eventually be called upon to recuse themselves. Then lastly, is at the same time, these considerations do not mean that a judge can never engage in expression, association, or assemblies that touch on issues or parties that could speculatively come before the courts at some future point. And total isolation from the community and society is neither realistic nor legally required of judges in terms of international law. So obviously, I have not gone through everything that the ICJ has adopted in terms of what we submitted to the United Nations Special Rapporteur, but I've just highlighted some of these and the key ones. And these reports or these submissions are available online for anyone to engage with. Now, but what are the international standards? You will see, of course, that the submissions that the ICJ made and some of the international standards that then emerged, there is a relationship. So on 29 April 2019, the United Nations Special Rapporteur on Independence of Judges and Lawyers published his report to the United Nations Human Rights Council, in which he discussed extensively the international standards on freedom of expression. And obviously, because I've got 15 or 10 minutes left, I don't want to go into extensively into the details of these standards, but I'll just highlight the key ones that are potentially relevant for the conversation that we're having this afternoon. So number one, like everyone else, judges are entitled to the freedom to express their opinions. Judges are also members of society and have both the right and moral duty to speak out their views, especially, but not limited to, in situations where there is a breakdown of constitutional order. In addition, judges have a right to express their views on matters, including legislative and other political decisions, which affect their independence and professional interests. Number 3 is that after expressing their views on such matters, judges should not be victimized directly or indirectly. The number 4 is, however, in order to protect the dignity and impartiality of the judges or the judiciary, as well as protect public confidence in the institution, it may be necessary to impose restrictions on the exercise of these rights by judges. But however, the restrictions must meet the following requirements. One is that they must be prescribed by law. Number 2 is that restrictions must serve a legitimate aim. Legitimate purposes or aims include the maintenance of the authority and impartiality of the judiciary, protection of the rights of others, the need to protect public confidence in the judiciary, the need to preserve the dignity of the judicial office, and the impartiality and independence of the judiciary. Then the third requirement is that restrictions may be imposed only if they are necessary. In other words, it is not enough to say restrictions are desirable or are convenient in this instance. Restrictions may be imposed only in circumstances where they are necessary. The number 4, which is the last requirement, is that restrictions must be proportionate. This implies, amongst other things, that restrictions must be appropriate to achieve their protective function, be the least intrusive instrument amongst those that might achieve the protective function, and be proportionate to the interest to be protected. And I think, as Pierre would say when he was teaching us, when he was teaching me, you must not use a sledgehammer to crack a nut. That's basically what it means to be proportionate. The principle of proportionality has to be respected not only in the law that frames the restrictions, but also by the administrative and judicial authorities who would be applying the law. These are the key sort of norms and standards that operate at an international, but at the regional level as well, because you will see that when you look at the resolutions and principles adopted by the African Commission, for instance, here in Africa, and the Inter-American Commission in the Americas, you will see that there is a relationship between what has been agreed, or the consensus at the United Nations level or at the global level, and the consensus at the regional level. And obviously, I expect now that the presenters who are coming here, especially I think Pierre, he would expand on the application of these standards in domestic jurisdictions, and whether and what it means in specific circumstances that arise in domestic jurisdictions. So thank you very much. I will hand over back to you, Kajal. I think I've saved 10 minutes of your time.
Thank you so much, Justice. Your timekeeping was excellent. The next presenter is Professor Pierre De Vos. Professor De Vos will present to us on the nature and extent of the limitations to freedom of expression for judicial officers. Professor De Vos is a renowned constitutional law scholar and expert. He is the head of the Public Law Department and teaches constitutional law at the University of Cape Town. He is also the Claude Leon Foundation Chair in Constitutional Governance at the University of Cape Town. Professor De Vos is widely published and writes a regular blog titled Constitutionally Speaking, which I'm sure many of you will be familiar with. The blog deals with political and social issues in South Africa from a constitutional law perspective. And with that, I invite Professor Pierre De Vos.
Okay, thank you, Kaja, and thank you for Commission and Justice for inviting me to speak here. I am going to speak using the South African example and trying to figure out some principles and practical application using, again, the South African context. Now, we all know that in any professional or any professional job, there will be some limitations placed on one's freedom of expression. If you're in the workplace especially, you might not be allowed to say certain things. In the South African context, recently it has been stated that even things you say outside of the workplace might be used by the employer to discipline you. For example, making racist posts on Twitter or Facebook and so on. Of course, judges are different, judicial officers are different, in that there are more extensive, usually more extensive limitation placed on the freedom of expression of judicial officers. And so the question is, where is that balance? And where is the sweet spot in that, in creating a system that is going to protect the judicial system and the authority and legitimacy of the courts, but at the same time is not going to muzzle judges to take part in important discussions. So the starting point, I think we're probably all going to agree on that, is that the default position is that judges and judicial officers should have enjoy the same rights, also the right to freedom of expression. And if you are going to limit the rights of judicial officers, it has to be done by legislation. It cannot be done arbitrarily, and it has to be done for a legitimate and important purpose. For me, thinking about this, what is most difficult is that when it comes to judicial officers, what one says might be just as important as how one says it. And that's very difficult to capture in a code of conduct or law and so on. And I'm saying that because in the South African context, we recently had a case of the Chief Justice who was found guilty by a Judicial Conduct Committee of breaching the code of conduct for saying certain things in support of the State of Israel in a webinar. And so I think in that case, arguably at least some of the questions raised was not necessarily only what the Chief Justice said, but also how he said it. So that is a very difficult thing to deal with if you write down a code or if you interpret the code. The starting point is, again, the independence and effectiveness of the judiciary and of the legal system. And so it's for that reason that some limitations are actually imposed. In the South African context, how that works is that the legislation, Judicial Service Commission Act, provides for a code of judicial conduct that has to be approved between the Chief Justice and the Minister of Justice. They both have to agree to try and make sure that the judiciary, or the leader of the judiciary at least, retains a final veto over what goes into the code. So that is a very important protective mechanism so that the code could not be used to muzzle judges or judicial officers in impermissible ways. In terms of that code, and in terms of the legislation that gave effect to it, judicial officers can then be disciplined through, there will be a hearing, a conduct committee, and then if it's serious enough, a tribunal. It can ultimately lead to impeachment, although that has never happened in South Africa. And so for me, what is interesting is maybe to use the code that was passed in South Africa as an example and see what works, what doesn't work. The code really imposes three different types of limits, it seemed to me, on judicial officers. And the first limit is that judicial officers should show restraint when commenting on legal matters or on specific court judgments. So in terms of Article 11(1)(f) of the code, judges or judicial officers are prohibited from public criticism of other judges or another branch of the judiciary, the lower courts, whatever, unless it is germane to the judicial proceedings before the judicial officer concerned, or to scholarly presentations that is made for the purpose of advancing the study of law. It's important here, and I think this is a very important limitation of the limitation, a very important exception to this rule. Article 11(2) of the code specifically say that a judge or judicial officer may participate in public debate on matters pertaining to legal subjects, to the judiciary, or to the administration of justice. But, of course, this is the how part, but does not express views in a manner which may undermine the standing and integrity of the judiciary. I think this is a very important distinction in the sense that it recognizes that judicial officers sometimes not only have a right, but have a duty to speak about things that might be wrong in the legal system, in the administration of justice, and so on. And also recognizes that judicial officers have a contribution to make in developing and thinking about the law, and to attend academic conferences, to make presentations and so on, as long, of course, as it is done in appropriately respectful manner. In the South African context, I remember after 1994, what was quite striking was that judges appointed to the newly created Constitutional Court, when we as academics had a conference, a judge would come, the judge would take part in the discussion, and it was a learning experience for everybody involved, and it is also a good advertisement for the judicial. So that is the first possible limitation, but also then the limit on the limit. The second limit that is imposed by the code is relating to what is said outside of the legal sphere, in other public fora or even private events. And so here, this, Article 12.1 of the code prohibits a judge from belonging to any political party or secret organization, and from using or lending the prestige of the office to advance their own interest or anybody else's interest. So you cannot sort of promote other causes. Also, and this is very important, it prohibits in Article 12.1b of the code, judicial officers from becoming involved in any political controversy or activity, unless, once again, that qualification, unless it is necessary for the discharge of a judicial office. So this provision therefore says that a judicial officer should be careful not to get involved in controversial matters that, if they get involved in it, is going to reflect badly on the impartiality and the independence of the judiciary. But as we'll see a little bit later, there can be difficulties with this. And lastly, Article 16.3 of the code states that a judge who reasonably believes that a colleague has been acting in a manner which is unbecoming of judicial office must then go and report this to another colleague or to the head of the court. So there's a limitation, I think, although the section is a little bit vague, but there seems to be implicit limitation here, that one is not, as a judicial officer, one cannot go public and reveal, say, corruption or other maladministration on the part of a fellow judicial officer, which in some contexts can be problematic. Whether the code can be read differently is an interesting discussion. So, having used the example of the South African code, let's go and think about how one will think about these limits and whether the limits are justifiable or not. Being a constitutional lawyer from South Africa, I'll use the South African framework, where if there's a limitation of a right, the question is whether the limitation is justifiable in terms of the limitation clause. It is the kind of proportionality analysis that Justice has also referred to. And here the usually, I mean, in the South African Constitutional Court at least, has a slightly, interestingly enough, slightly less strict test for a limitation being not justifiable, in that it doesn't require that you have to show that the limitation is actually necessary to achieve a specific purpose. It is more of an overall balancing test. So the metaphor of a scale is often used in the South African context. The famous case of Christian education versus the Minister of Education in 2000, the court explained that you really have to balance two different types of interest. On the one hand, you look at the right. What is the nature of the right? How important is it? how severe is the limitation? So if you're going to think about limits imposed by a code of conduct on judicial officers, you're going to ask, so how far does it go? Freedom of expression is obviously very important in certain contexts, where especially where the judiciary is under attack, it can be even more important. But the question then is the limit, how severe is the limitation? Is it going further than is necessary? That you put on the one side of the scale. On the other side, you look, of course, at what the purpose, the importance, and the effect of the limiting provision is, and whether there are less restrictive means that could be used to achieve the same purpose. So if you use that test, let's go and think about the provisions that I've spoken about now. Firstly, the purpose, as Justice has also alluded to, of imposing some limits on judicial officers' right to freedom of expression usually has to do with the impartiality and the independence and integrity of the courts. The assumption that these are not only affected if judicial officers in fact are not impartial, if they are in fact biased, but also if a perception arises about that. So that, I think, is one of the most important reasons why some limitations on judicial officers' right to freedom of expression should be permitted, because if judicial officers could say anything that they want, the perception might arise that the judicial officers are not actually impartial, that they get involved in political disputes and so on. A second reason I think that's also rather important is the fact that the possibility of recusal arises when one expresses a strong view about a specific matter that then get to the court. And there is a duty normally on judicial officers not to recuse themselves unless it's really necessary, and not to put themselves in a position where that is required. So this means, I think, given these purposes, as if the code of conduct that limits the freedom of expression of judicial officers are truly aimed at achieving these purposes, then it will be more difficult to argue that the limitations are not justified, that they are problematic. Of course, there are many other reasons why limitations could be imposed on the freedom of expression of judicial officers, including muzzling them from speaking out when the judiciary itself is under attack, or being the independence is being eroded, or even not criticizing other judgments of higher courts. We have the case of the Uganda Supreme Court, where one justice seemed to have been muzzled, allegedly for wanting to write a dissenting opinion, those kinds of things. So this means that I think most of the code in South Africa, at least as I explain it now, it does try, it appears from on its face that the purpose of these limitations are in fact to protect the judiciary, and not to achieve another ulterior purpose, or a purpose that is would not really justify a limitation. The problem comes in, of course, with the other side of the scale, when you ask how severe is the limitation? How drastic is it? Are there other ways of achieving the same purpose by limiting the rights of judicial officers in a less drastic way? We can think about that, but I think mostly the clauses in the code strike the appropriate balance, but there are some questions, I think. One of the things that I find quite perplexing is the second limitation that the South African Code imposes, which says one cannot get involved in and make statement that involves one in a political controversy. On the face of it, it makes perfect sense. The judges shouldn't become involved in party politics or these kind of political controversies. But what is a political controversy? So in a certain context, in a certain jurisdiction, merely stating that courts are independent and impartial, and that the independence shouldn't be eroded, that decisions are made based on the law, interpretation of the law, and not on other extra legal considerations, that could be politically controversial. So maybe one might have to think about another way of phrasing this to capture the intention here without leaving open the door for limitations to be imposed for reasons that are not actually justified in terms of what the law says. Lastly, the question about judges or judicial officers being prohibited really from publicly, except in court proceedings, reflecting on another judgment, from publicly criticizing another judge. There are very good reasons, once again, for this. The integrity of the judicial system, if the judges are starting to fight, where I stay in the Cape Town, the local division here, the judges are fighting with one another, and it is reported in the paper, and it's not really good for the judiciary. But in a system where there are problems with the judicial officers, with their integrity, with work ethic, whatever the case might be, sometimes it might be required for one judicial officer to go public and alert the public to another judicial officer, and the misconduct of that judicial officer. So I would think that such an absolute blanket limitation on the right of a judicial officer to alert the public to the problems with another judicial officer might not be appropriate. But of course, this, once again, there needs to be some kind of limitation imposed, otherwise it will be a free-for-all. So in conclusion, I don't know how much time I have, but in conclusion, it seems to me that the most important question, that is, if you have to make a kind of proportionality analysis, is always going to be, what is the intention behind the limitation and what is the actual effect of the limitation? Because sometimes even limitations that are imposed for a benign purpose can have a disastrous effect. If the purpose is appropriate and the measurement, the limitation is appropriately tailored, specifically only to do what is necessary without infringing on the rights further than is necessary, it should be appropriate. But of course, in the South African context, the Chief Justice has appealed the decision against him for getting involved in a political controversy by making pro-Israel statements. It might, we don't know what will happen. The Chief Justice may try and challenge the code of conduct itself in the court of law, which would be a very interesting case. And then the South African courts will have to clarify whether these provisions, including the prohibition on judicial officers getting involved in political controversies, whether that goes too far, whether it's too open-ended or not. So that really is all I have to say for the moment. Thank you very much.
Thank you so much, Professor De Vos. I suspect that there will be many questions directed at you during the Q&A session. Our next presenter is the Honourable Judge Professor Oagile Dingake, who is a Justice of Appeal at the Court of Appeal of the Seychelles. He also serves as a judge of the Residual Special Court for Sierra Leone. Previously, he served as a High Court judge in Botswana. He is also an adjunct professor of public law at the University of Cape Town, a member of the Judicial Institute for Africa, which promotes continuous learning for judges in Africa. Justice Dingake will be presenting a judicial perspective on practical considerations to be made when exercising freedom of expression. Justice Dingake. Justice Dingake, we're not hearing you. Perhaps you need to unmute. Perfect. We are seeing you.
Hello?
Yes, this is good.
Is it okay now?
It is good. We only see the top of your head, so maybe to adjust your screen. Perfect. Perfect.
Is that better?
Much better. Thank you.
Thank you so very much, Kajal. Good morning, good afternoon, good evening, and I don't know whether good night applies. But I want to thank the organizers of this event for inviting me to share some thoughts with the participants and the panelists, and to say that I'm very happy to be sharing this platform with colleagues that are my friends who I know very well. Professor, we have shared a platform together at JIFA, at the Judicial Institute for Africa. We facilitated together some years back. And just this, I didn't know he was a product. I thought he was my product. But he says he is your product. I'm happy again to meet him in this forum. Let me just say that our discussion is quite timelessly and relevant, given recent developments that have been taking place in some parts of Africa, in South Africa, on a matter that Professor has mentioned, a country with a very progressive constitution, at least the constitution now to be among the most progressive in the world, and also taking into account recent developments in Uganda. So this particular discussion is of some relevance. Of course, at the end, when Professor De Vos spoke about the possibility of challenging the code of conduct itself, my skin crawled a bit because I have often wondered at the wisdom of providing in so much detail some of the provisions similar to the Judicial Code of Conduct in South Africa. And when those details cannot be found in the Constitution, when whether there are serious implications in terms of possibly finding that the Judicial Code of Conduct may not be in compliance with what the Constitution says. Having said that, and because I'm operating within the limitation of 20 minutes, let me just say that I adopt most of what Justice and the Professor said as my own. I think they were spot on a matter of the legal regime at the international level. But interrogating the matter of judicial free speech limits is literally in my mind like peeping into the soul of the judiciary. To determine, to explore values such as the rule of law, the independence of the judiciary, and by that I mean the institutional independence and the independence of a judge, matters relating to the integrity of the bench, impartiality, and the need to safeguard the dignity of the profession. And all these values that I've spoken about are critical when we come to discussing the permissible limits of free judicial speech, because they serve as constraining factors or contextual considerations around which a proper interrogation must be done. There are, of course, a few other contextual considerations that may determine whether a judge who expresses himself publicly is exceeding the bounds of legitimate bounds of free speech. First is the value of free speech itself. It is generally agreed among many lawyers, including among many constitutional lawyers, that free speech is a public good that ought not to be unjustifiably interfered with. But the devil is always in the detail. The articulation of the principles and the general international legal framework is easy, but the real devil is in the detail. In a famous constitutional law judgment that is often cited by constitutional lawyers in the US, the dissenting remarks of Holmes J.A. emphasize the ultimate good desired is desired where there is a free trading of ideas in the marketplace, and said that actually where pursuit of the truth is at stake, then we must draw very narrowly the limitations around free speech. The above approach confers the widest degree of immunity upon speakers in general, including judges. And I agree that judges, like any other person, as a basic premise of departure, are entitled, just like any other citizen, to freedom of expression. But with judges, there are those constraints that the professor mentioned, around which we must interrogate this test. Some countries provide that any limitations around free speech must be reasonably justifiable in a democratic society. Others use the necessity test and the proportionality test, but that is not the universal test in most of our jurisdictions, meaning that the extent to which freedom of expression is protected in South Africa may vary with the extent to which it is protected in Botswana, in Zimbabwe, in Swaziland, or in Uganda, depending on how the relevant provision of the constitution that protects that right is framed or couched. But generally, the convention appears to be that a judge is a neutral arbiter, and that as a result is bound by convention to try to remain as neutral as possible. And the convention seems to suggest that a judge should be seen and not heard. Although increasingly these days, judges are being heard, but they're being cautious not to offend the certain precepts that underlie the essence of being a judge. I have indicated that the general law may differ from one country to another, depending on what the relevant provisions in a constitution relating to free speech stipulate. In some countries, the stipulation is almost in absolute terms and says everyone has freedom of expression. And it stops there. If it says that and it stops there and does not impose any limitations, issues may arise if you have a judicial code of conduct that has limitations. To what extent does it square up to the constitutional provision, which is superior, obviously, to a judicial code of conduct? In other countries, like in Botswana, all the rights in the Bill of Rights are, of course, subject to limitation. And the test is not necessity or proportionality, is that any limitation must be reasonably justifiable in a democratic society. So the view that judges have freedom of expression, of course, finds support in international legal instruments that were mentioned by Justice. But I think of fundamental importance is what does the individual constitution in a particular country say? What is the text? How is it formulated? And what is the spirit behind the formulation of that text? There are some scholars who say that because the judiciary is another arm of the state, others say an arm of the government, it should not operate like a submarine. It should not whisper in corners. It shouldn't go down and deep and remain silent and operate like a submarine. Instead, it must articulate any discomforts that are there in the legal system, so long as that does not compromise the independence of the judiciary. So the question always is where the edges of that role begin and end. I'll cite two case studies. Will never all of us agree as to the limits, and most certainly will never agree with politicians as to the limits of freedom of expression. And I want to steer away, of course, from the case, the South African case, because I do not know, sitting here physically in Botswana, but engaging virtually with a global audience, if I do, I would offend in the sub judice rule, or is inapplicable. But that is beside the point. Two case studies that I'm safe to discuss, and not the South African one, and possibly not the Ugandan one, took place long time ago in New Zealand and in Australia. Because they took place away 10 years ago and are not subject of any litigation, I think I can cite them just to highlight how difficult the boundaries, to draw the boundaries are. In 2009, the Chief Justice of New Zealand, speaking at an annual lecture promoted by Women in Law Committee of Wilmington Branch in New Zealand, had expressed concern about overcrowding in prisons and the possible human rights implications of overcrowding in prisons, and had suggested possibly a number of options available, including pardons and exercise of executive authority to release them. He was severely criticized by the Minister of Justice, including the Prime Minister. The two of them believed that the judge had exceeded the legitimate bounds of freedom of expression, that he had gone overboard. And many of us here may consider that maybe they went overboard in their criticism, or others may agree with them. The second case, quickly, happened in 2001, and that involved my revered friend, Justice, now retired Justice Michael Kirby of the High Court in Australia, who addressed the graduation in Adelaide. He spoke about the importance of public education and suggested that there was some underfunding from the Commonwealth government about public education, and called for adequate funding of public education. And the Australian Education Union and the opposition joined him and said he was right. But the Attorney General and the Prime Minister took exception and said that the judge had exceeded the legitimate bounds of freedom of expression. Now, you can see how contested the whole space is and the whole discourse is. But wading through the literature around these issues and taking into account what my colleagues have said, it seems to me that we can come up with 4 tests for now. Maybe there are more, which we can use to determine whether a judge has exceeded the bounds of legitimate expression of views. And as I say, it will depend from one country to another, and it also depends on the legal framework in that country. But let's say, for argument's sake, before I quickly go through those tests, in the context of a country in the legal system of Botswana, where the death penalty is constitutional, with a judge who says that he finds death penalty barbaric and offensive to the rule of law, or a violation of fundamental human rights, in a situation where the Constitution states that it is lawful or constitutional, would he be engaging himself in political controversy? Or the controversy is legal, not political, and therefore he is secure? What about a judge who speaks at a graduation, at a university graduation, and in a moment of political discourse says that he actually, upon further reflection, he thinks that apartheid was not as bad, after all, as it is made out to be? Would a judge have involved himself in political controversy? What then are the limits? So I do think that, yes, we can answer the question affirmatively, that like any other citizen, a judge has freedom of expression, subject to certain limitations that take into account the very essence of what being a judge is. And I would say that the 4 tests that can be used to gauge whether a judge has gone beyond legitimate boundaries may include the following. One, whether the maintenance of the independence of the judiciary has been breached. Can one say out of what a judge has said, if the answer is yes, in saying whatever he did, he compromised the independence of the judiciary, then it is possible then to hold that the judge exceeded the legitimate bounds of freedom of speech. The next other test is the preservation of judicial impartiality, that demands that judges refrain from any appearance of impartiality or sharing prejudice publicly or prejudging a case. So if whatever a particular judge, Judge A, B, or C, has said is found to have been offensive or inappropriate, the question must be asked whether it does compromise the judge's impartiality or it amounts to prejudging a case that may come before the judge. If the answer is yes, then the limitation that may be imposed on a judge may be reasonable. And of course, although it's easier said than done, it is generally agreed that the judge should avoid engaging in a discourse that may involve him in political controversy. And that alone is loaded. Maybe it will take weeks to unpack what is political controversy. And the last one is that judges should avoid causing, of course, controversy gratuitously. So those are my take on this particular interesting topic. But by way of conclusion, I think I'm still within the 20 minutes. All being said and done, it seems to me that the old order of restraint, although still in place, that judges must be restrained in view of the nature of the office they hold, where they are required to be independent, to be impartial, and that sometimes perception matters more than fact, and that they must always be conscious of that. All that being said, a judge must be free to express himself, but cautiously, ensuring that it does not undermine the essence of what it is to be a judge. And having said all that above, it seems to me that as a general rule, the judgment of what constitutes impermissibility should be left to the individual judge concerned. It is only where there is a prima facie case of clear possible violation of a judicial code of conduct or the legitimate bounds of free speech that we can bring on board disciplinary authorities or proceedings against a judge. But what I am saying, in effect, is that we must be very restrained in going to that extent, unless it is clear that there is a basis to call upon the judge to answer to that kind of conduct. Because any disciplinary proceedings against a judge ipso facto undermine the very authority of a judge and may, in certain situations, be viewed as undue influence or pressure on a judge, and to the extent that it may compromise his independence. So judicial function is such that any reprimand or disciplinary process around free exercise or free speech must be restrained. However, I must finish off by saying, we are not sacred cows. We can commit costly mistakes. We can exceed our legitimate, we can go outside our legitimate plane. But sometimes criticism of the public, including that of the press, on a judge that is seen to have erred is adequate in itself and may simply keep the judges in line if it is done respectfully and it's a legitimate criticism and is done in good faith, even if it may be misguided. Permit me to rest this far, Madam Facilitator. Thank you very much.
Thank you so much, Judge Dingake. That was greatly appreciated. So the next presenter is Professor Jill Cottrell Guy. Professor Guy is a renowned public law scholar and intellectual who has taught law at the University of Hong Kong, Warwick Law School, and Ahmadu Bello University in Nigeria. She has consulted for various institutions, including the United Nations Development Programme, on matters such as constitution building. She's currently one of the leaders at the Katiba Institute, an organization which promotes constitutionalism in Kenya. Professor Guy's presentation will focus on contemporary developments, challenges and impediments to freedom of expression for judicial officers in East Africa. Professor Guy, over to you.
Thank you very much indeed, and it's a great pleasure to be here. I've find myself with some slightly disorganized thoughts, especially because some of the speakers before me have very much said the sort of thing that I was thinking of saying. But let me just comment first of all that just over 30 years ago, Yash Guy and I moved to Hong Kong. And we found there a Chief Justice who took a particularly narrow view of what judges might do and say. Basically, they were not allowed out of their judicial role. Specifically, he didn't allow them to come to law faculty seminars. A few of them did sneak out when Yash organized a conference on the new Bill of Rights in 1991. They were very concerned that the Chief Justice should not hear of it. And in those days, people, of course, didn't tweet what happened at the conferences. I think that Chief Justice was particularly conservative in various ways, and perhaps insecure in some ways. But it just goes to show a certain traditional view of what judges might actually say, other than sitting on the bench. His successor, however, was completely different. He used to come to faculty seminars himself. Of course, he and other judges were cautious about what they said, at least in gatherings of more than 2 or 3. But maybe those 2 judges themselves were each on one side of a different side of a sort of dividing line between more traditional and slightly more relaxed approaches to what judges might do off the bench. I have to confess that when I saw the title of this webinar, I thought, sounds like a contradiction in terms, judges and freedom of expression. Of course, they don't have freedom of expression. I suppose that was a rather traditional view too. I was thinking of the judges who have complained to me mildly in the days when I was teaching in Nigeria, that once having become a judge, their social lives were so truncated. There were so many things that they couldn't do, and in a sense, their vocalizing lives were rather restricted too. Of course, judges do, in one sense, have freedom of expression for what they say on the bench. The Constitution incorporates that rule of the common law and says that judges cannot be held liable for anything done in good faith in the lawful performance of a judicial function. In 2 phrases, or words and phrases, that it's perhaps slightly different from the common law rule. It's a little bit restricted. Who must show that it was in good faith? And exactly what does lawful mean, especially as linked to good faith? If a judge believed herself to have jurisdiction, but in fact did not, does this protection apply? Under this statute, under the old Constitution, the statute would protect somebody who acted without jurisdiction, did so in good faith, and therefore was technically, if you like, unlawful, but not acting out of any wrong motive. But in reality, the Kenyan courts have found little difficulty in holding the judges completely protected. The Supreme Court seems to have implied that lack of jurisdiction even does not defeat immunity unless it is in bad faith. when it said, as was observed in an American case, to amount to impunity, distinguished from immunity, a judge's act must be a clear and deliberate seizure of absent jurisdiction. They tend not to focus very hard, I think, on the words of the Constitution itself, but this is something that all judges have been brought up with, so they're quite familiar with the situation. On the face of it, you might say that the Constitution seems to narrow the traditional immunity in English law, which in the context of defamation at least, has been that of absolute privilege, that even malice, an improper motive, would not defeat the privilege. It's always intrigued me that in the middle of the last century, an English Chief Justice thought that this absolute privilege was unjustified, but I haven't noticed many judges since then taking that view. However, most of the people who try to sue judges for what they say on the bench seem to be people who are trying to overturn a decision they don't like. And much more difficult to deal with are, if you like, extrajudicial pronouncements, which is what we're mainly focusing on. But I did want to pick up on one point that Pierre De Vos made, which is about dissenting judgments. I was not familiar, I have to confess, with the Ugandan case. It's sort of, thinking about what he said, it occurred to me that it indeed is true that in some systems there is a discouragement of dissenting judgments or concurring judgments, or perhaps there's a certain nervousness on the part of the judiciary that particularly when you have rather authoritarian regimes, that they would rather stick together and have a single judgment than stick their necks out and make especially a dissenting judgment. And Singapore's Court of Appeal is notably prone to give judgments of the court. And the Kenya Court of Appeal used to be, I think it's changing a bit. In fact, Chief Justice Mutunga, who was Chief Justice for the first Chief Justice under our new constitution, positively encouraged the judges, I think, to make dissenting and concurring judgments. This is very different between different systems. So it can't generalize, but in the common law system, it is, in some extent, an aspect of the freedom of expression of judges to be able to make a dissenting or a concurring judgment. On the question of codes of conduct, the Kenyan code was revised in 2020. Comments, and one is what you would expect perhaps. A judge shall primarily speak through his or her judgment and shall not enter into correspondence with a litigant or other person about the case. That's fairly obvious. A judge shall not comment on proceedings pending in any court and shall require similar abstention on the part of court personnel who are subject to the judge. But there is an interesting comment. A judge may make statements in the course of his or her official duties on or explain for public or private information the procedure of the court. Provides, so not apparently on the substance, but on the procedure. Improvements are not prejudicial to the integrity of the judiciary and the administration of justice. And a very interesting addition, I think. A judge is responsible for his or her online activity and should avoid any activity, action, or association that may reflect adversely on the judge's impartiality or interfere with the performance of judicial duties or status of the office. The linking between the first part and the second, which second one seems very general, the first one refers only to online activity, is a little odd. One assumes that the any action, activity, or association, whether online or not, that would reflect adversely on the judge's impartiality is prohibited. Judges must not bully or engage in sexual harassment. And a Then there's another very Kenyan addition. A judge shall not solicit for contributions from the public for a public purpose, unless the president has, by notice in the Gazette, declared a national disaster and allowed a public collection for the purposes of the disaster. And a judge shall not participate in a public collection of funds in a way that reflects adversely on that judge's integrity or impartiality or interferes with the performance of his or her judicial duties. This business, the Harambee, which is a tradition of in Kenya, is very political, and the desire is to keep judges away from what does very easily become a highly political sort of activity. I understand that in addition to the code of conduct, there is a practice, but that is not written down in the code or apparently anywhere else, that judges must ask the Chief Justice before they speak at conferences and so on, and that this is actually respected. Under the code, they may teach and so on, carry out research. They may not be paid. So a judge may not be a part-time teacher with a salary, apparently. I was unable to read the Tanzanian code, but the Ugandan one has similar, although it is briefer, I think. A judicial officer shall refrain from all active political activity or involvement, and from conduct that in the mind of a reasonable, fair-minded and informed person might give rise to the appearance that the judicial officer is engaged in political activity. Apparently in Uganda, lawyers do sometimes complain about insults from the bench, which is a somewhat slightly different issue of freedom of speech. But then that reminded me that in Kenya, after the new constitution, there was a process of reviewing existing judges and dismissing some of them. And at least a couple of them were dismissed partly because they had an abrasive style in the way they addressed the bar. They were women. I seem to me to raise some problems. There's a very subjective issue of the style of a judge in dealing with the bar. If I might pop to the other side of the continent, it was interesting to note that the Nigerian Code of Practice says that in accordance with the fundamental rights enshrined in the Constitution, a judicial officer is like other citizens entitled to freedom of expression, belief, association, and assembly. Then goes on to qualify it: in exercising such rights, he shall always conduct himself in such a manner as to preserve the dignity of his office and the impartiality and independence of the judiciary. That's the one as I say, the East African ones did not seem to acknowledge the issue of freedom of expression as such. Reflecting on the implications of limits, first of all, there is the problem: what does one do with a judge who violates codes of practice like this? It's always been a problem in the common law system, especially with the superior judiciary. What can one do with them short of sacking them? But bad, unwise statements on the bench or in private or in public may not amount to gross misconduct justifying dismissal. And the Judicial Service Commission has very limited scope between superior court judges. Maybe somebody can have a quiet word, as was the tradition in the background, but there's no formal possibility of disciplining. So what happens to judges who actually misbehave, unless they do it so regularly that they can be said to be violating the Constitution and guilty of gross misconduct? And then I was thinking, what about Chief Justices? Because the Kenyan system is carefully, as I said, sort of controlled to the extent that people who are going to speak at conferences and so on should get the approval of the Chief Justice. But who approves what the Chief Justice says? I'm not suggesting Chief Justices have been violating, but then I wanted to pick up very much the point that, again, Pierre De Vos was making. And our constitution is not absolutely identical, but is very similar to the South African constitution on the question of when rights may be limited. And here we have a situation in which, indeed, the rights of members of the judiciary are limited. That's obvious. Normally, and indeed, as somebody commented, in any profession, you may well find that your rights are limited. But the first criterion for something to be a limit is that it should be in law. And exactly what in law means, I'd be interested to see what other people think. This is a code of practice. It refers to itself as a guide. It is made admittedly by the Judicial Service Commission. And if I can find the initial phrase, it says, in exercise of the powers conferred by the certain section of the Judicial Service Commission, read with Section 37 of the Leadership and Integrity Act and the Public Officers Ethics Act, the Judicial Service Commission makes the following regulations. So regulations are normally law. And yet the language also is of a guide. But if it is law, then there's an implication of being law, right? Which is that it should be clear. People should be able to know what it is they're not supposed to do in order not to infringe the law. Yet the drafting style of codes of practice is somewhat lacking in precision and specificity. And a great deal of subjectivity is really built into some of the notions in these codes of practice. Things that might cast doubt upon somebody's impartiality and so on. So I'd be interested to see how people feel about the lawness of codes of practice that limit what judges may say. I finally wanted to say something which, in the Kenyan context, I think when people think about freedom of expression, they probably think of some of the more dramatic events that have taken place over the last few years as between the judiciary and the executive. And of course, probably many people are familiar with the fact that in 2017, the Supreme Court historically declared the election of the president unconstitutional. Because of failure to observe the constitutional principles in the conduct of the election. The president was furious, especially the second day. He was sort of mild the first day. The second day, he really lost his cool and threatened to revisit the judiciary and so on. And this type of reaction, certainly you think with maybe with all judges, but certainly perhaps judges at lower levels, would have some inhibiting effect on their expression on the bench, that is. I have to say that Parliament too can be a little overzealous in its criticism of the judges. Generally speaking, there are subtler ways of dealing with it. In other words, simply not doing what the courts have told one to do. But in the case of an election petition, that's more difficult. So that's an additional element, which, as I say, to the Kenyan mind might come fairly prominently, which is a sort of discouragement of frankness and honesty, even on the bench, emanating from the other governmental agencies. Thank you very much.
Thank you so much, Professor Guy. That was very interesting and very useful. And before I introduce the next presenter, I just want to point out to the panel that there are some questions which are being posted in the chat. So if the panelists would like to start looking at those questions and preparing to respond to them once we get to the question and answer session, that would be great. And to introduce the final presenter for this afternoon, who is Judge Radmila Dragicevic-Dicic. Judge Dicic is a judge of the Supreme Court of Cassation of the Republic of Serbia. She also serves as Vice President of the International Commission of Jurists. In 1997, during the regime of Slobodan Milosevic, Judge Dicic was one of a number of judges who established the Association of Judges of Serbia. The main goals of the association were to improve the judicial system and to promote the independence of judges, and to resist violation by the executive of the basic constitutional principles and international legal standards. Judge Dicic will this afternoon present on the experiences regarding challenges and impediments against freedom of expression for judicial officers in Europe. Over to you.
Okay. You hear me?
Yes, we hear you very well.
My greetings to all of you, my colleagues that I know, that I have heard for, and a special greetings and welcome to Justice Alfred, that he came to be our global coordinator to such important Center for Independence of Judges that I always favored and thought that is one of the crucial parts of the International Commission of Jurists. When I'm coming now from this other part of the world, and I will try in this 15 minutes, I think that is left, to tell you about the situation in Europe, and I will focus on the situation in Eastern Central Europe, some countries that are members of European Union, and also to the countries like Serbia, Bosnia, and regional countries, but in European Union, but having specific problems connected with constant judicial reform, constitutional reforms, law reforms. And as I was presented at the beginning, my personal history has to deal with the fight for the independency of judiciary and everything that we went through in Serbia. And the similar was for the rest of the countries of ex-Yugoslavia. And I just want to stress the real importance of Association of Judges, that they can step in front of all judges, be their voice. That is what was really revolutionary and good experience in Serbia. And we managed since now to influence many events and reforms in Serbia to somehow question under the constitutional law and constitutional court, and to raise the issue of dismissal of judges, and then to have a good procedure to have a return of about 1,000 judges in a court system. So that's a really good history, but still country like mine and the other countries in region are fighting the same problems, and it is ongoing revolution, it is ongoing reforms of reforms. And what is the problem here? It is that, and I think not only Serbia, I'm now talking on behalf also for the countries like Poland, Hungary, that are having cases in front of the European Court of Human Rights. The problem is that countries in this part of the world are trying to have and having constitutional reforms that have the false reason, like they want to democratize judiciary, they want to make judiciary more independent, but really, when you grab behind those proposals are not real intentions. That is a big task for us to reveal it, and we went in front of Venice Commission, and that is also the big chance for judges who want to speak, to go out and speak about those issues. And this is not easy because at the same time we are having a strong government that are mainly populistic, not really democratic, and they are trying to oppress the voice of judges. What is the thing is like for that we in our code of ethics of Association of Judges of Serbia, which is accepted also by the Supreme Court and High Judicial Council, have also the part that said be brave, you know. And I'm asking myself, when will come the time when judges will not have to be brave, when we can just sit and deal with our cases? And then then we have always in those countries that I mentioned, a few judges that are outspeaking judges. They go out in the media, they talk on TV, they give statements. And then there's a big majority of judges that are, as I would say, old-fashioned judges, and they think really and deeply believe that it's wrong to deal with the cases, not to give the statement, and that everything that there's a danger that everything will be somehow politically treated. And that is also something that is historical, that we were dismissed in Serbia. We were dismissed as political enemies of the country, the traitors of the country, as the spies or whatever the ugliest thing that they could imagine for us. But actually we were fighting for the independence of judges, and even today, although I was on the street fighting with the students in the revolution being a judge, I think that I was not really politically acting, because that was the time when there was a misuse of judges, when they put the laws that were kind of really unlawful, unconstitutional. So that's the history now, but the task remains the same. And what I also wanted to stress, that I think that for countries like Serbia, and I think the countries in Africa with some problems in the democracy, in the problems of division of power, I think that it is really important to have and develop communication strategies. Communication strategies is something that should be taught by the Supreme Court and by the Association of Judges, and with the help of media. I think that media, together with judges and associations, are the safeguard independency and the right division of power. We have to send the core messages, and the core messages that we all, when we speak out, should be that courts are fair, impartial, independent, that courts exist to protect citizens and their rights, and also the laws brought by other branches should also be the same to protect the citizens and their rights, that the courts are transparent and accessible, the judges are held to the highest level of accountability, and the justice that everybody is equal under the law and under the justice. Those are the, and we are facing some real problems. And when I don't have time to go through some European standards and what I all prepared here, but what I think that is important for the Europe, the most important is really the work of European Court of Human Rights and the case law and the cases that are still in that court. And the leading case is Baku against Hungary, which I will just mention later if I have time for that. And we have, beside the European Convention on Human Rights, specifically Article 10 that deals with the freedom of expression. We have the statements and of Consultative Council of European Judges, and they also all talk about the freedom of expression and that it should be free on the judges. But then I would like to mention the European Network of Councils for Judiciary in 2013, statement that prudent convention that judges should remain silent on matters of political controversy should not apply when the integrity and independence of judiciary is threatened. there is now a collective duty on the European judiciary to state clearly and cogently its opposition to proposals from government which tend to undermine the independence of individual judges or councils for the judiciary. And I think this is a good statement that has to deal with the background of each specific situation and some case against the judges. And I also want to say that how some Bangalore principles can even be misused. In Serbia, we have a judge who is outspoken and who goes on the media trying to discuss about all the issues. Sometimes maybe he goes too far and it is on the edge of being political or not. And he's criticizing the other colleagues, criticizing the prosecutors not to dealing with the high corruption or whatever. And there was not a disciplinary procedure against him. One of Bangalore principles that says that judge can and may engage in other activities if such activities do not detract from dignity of the judicial office or otherwise interfere with the performance of judicial duties. So they took out, High Judicial Council gave the statement for the news, there was no disciplinary procedure, but somehow they used this Bangalore principle to say the judge in this case didn't care about the dignity of the judicial office. It didn't protect the dignity of the judiciary at all by criticizing the judiciary. So for me, it was kind of really smart and smart under the quotation and somehow an other way interpretation of that principle. When we talk about European Court, the European Court and the practice of the European Court, it is somehow really protection for the judges in all countries. And we have the constant problem, for example, with Poland and their reform, and I think you are all informed about that, trying to somehow take over the judiciary, Supreme Court, and so, but there is the leading case is Baku against Hungary, where the European Court of Human Rights brought the judgment, finding that Hungarian Supreme Court President Baka's premature termination as President of the Supreme Court, following his public criticism of Hungarian legal reforms that he believed undermined judicial independence, violated the European Convention of Human Rights, including Article 10 of that convention. And what is for me really important that they stated also in this decision is that that premature termination of the judge mandate undoubtedly had a chilling effect in that it must have discouraged not only him, but also other judges and court presidents in future from participating in public debate on active reforms or whatever issues dealing with judiciary. And that is what is also happening in the country of the regions. The judges who speak out, they are not really disciplinary charged. There's no disciplinary procedures, but they go, we have the saying of warm rabbit. Somehow they, in parliament, which is mainly one party, they are so attacked in parliament with on the worst way. Their private life is exposed. They are just, it's unbelievable. So this is all somehow that what they say, chilling effect on other judges not to go out and talk. And what is really important, and what I really think and believe in, that it is a duty of judges to act and talk in the situation like we talk about when it's for the independency and division of power. And I think that is a duty first of the President of the Supreme Court, President of High Judicial Council, President of the courts, even if you can endanger yourself, put yourself in a dangerous position, or maybe in the position to be dismissed. And that is what also European Court stated in this decision, that the applicant was acting in professional capacity as the President of the Supreme Court and the President of the National Council of Justice, and that it was not only his right, but also his duty as the President of the National Council of Justice to express his opinion on legislative reforms affecting judiciary. And I think that first justice, the President of the Supreme Court in each country should have this role and should take that responsibility. But very often it's not like that. And then when the other judges from the lower courts or their colleagues from the Supreme Court have or must step in. And I think that responsibility rises as the position of judge is higher. And I want to stress the constant determination and fight of International Commission of Jurists and our statement and our involvement in ongoing cases in front of European Court. And I think that is so visible. That is in the case Jurek against Poland, where we wrote a submission. That is a statement for the case Judges Markiewicz, also Poland and Hungary case. And I would like to finish with one happy ending. And also I forgot to mention Judge Igor Tulev from Poland, but no time for details. That there was a case a few years ago with prominent Judge Branko Peric from Bosnia and Herzegovina, who was commenting publicly cases on war crimes in Bosnia, but not really dealing with special cases, but dealing with the influence of politics and executives that are reflecting to those cases in front of Bosnian courts. And this is really sensitive in Bosnia and in Serbia, also in Croatia, where we still deal with the war crimes. And there was a disciplinary procedure brought by the prosecutor against him, but the Commission of High Judicial and Prosecutor's Body discharged those charges against him, and somehow they became final. And Judge Peric has really a good process and defended himself, and that was something that was also good for the region. And my question for all of you is a question that we are raising in the Europe and raising in the region, is having some judges who are having their permanent columns in the newspaper, having the blogs, they're on social medias, expressing their views on different issues, sometimes on the legal issues, and still we don't have a strict opinions about that. It was not brought in Serbia as an issue, but somehow it is a latent danger that it will come out. And if someone has some opinion about that, I would like to hear. I think my time is gone. Yeah, okay, I will finish now. Thank you.
Thank you, Judge Dicic. And with that, we will open for questions. I understand that there have been many questions submitted already, and Justice is going to assist us to outline those questions and to direct them to members of the panel. Justice, if you can commence with the questions.
Sure. Thanks very much, Kajo, and thank you very much to our esteemed speakers, of which I think I was one of them. I may not have been esteemed, but I think Pierre, Honourable Dingake, Prof. Jill, and Judge Radmila were very, gave very illuminating presentations on this subject. So now we have received a couple of questions, and I'm going to appeal to our panelists to be very brief, even though the questions are complex, but to be very brief because we only have 20 minutes, but maximum of 30 minutes to go through this, because I think our colleagues have been sitting here for a long time. Let me start with a direct question directed to Pierre. So the first question is, what are your thoughts on judges commenting on foreign policy issues? Maybe before you go on, Pierre, let me check if there is another question which is addressed to you. The other question addressed to you is regarding the question of judges being members of political parties. This is a highly contested issue implicating not just freedom of expression, but also freedom of association and the right to political participation. The middle position is that membership of a political party per se is not inherently incompatible with the judicial function, as long as the judge is not playing an active or functionary role in political business or a political party business, which would project a lack of independence. What are the views of the panelists? So I would like you, Pierre, to weigh in on that. And of course, the other panelists, when I direct a question to you, and if you feel like you need to weigh in on any of these questions, please go ahead. Over to you, Pierre.
Thanks. Of course, you're going to ask me the difficult question about the Chief Justice. I would answer it slightly carefully, maybe uncharacteristically so, and say that, you know, there's actually a history of South African judges being critical of not necessarily of government policy, but of foreign governments, but phrasing it as a human rights abuse. So if you're a judge, you give a talk, you can say, in Myanmar, there is a coup, coups are a bad thing, this is not in line with democracy and human rights. That would be perfectly acceptable. If you go to a march in front of the Myanmarian embassy with placards down to the dictators, maybe the line is slightly, then you have crossed the line, because for me, I think the important point is what perception would a reasonable person form based on your expression. So reasonable people are not going to expect judges not to have opinions about what's happening in the world, but reasonable people are going to expect the judges to express it circumspectly, those opinions, and to bring it back to their personal expertise, which is the law, human rights, democracy. So I'm skirting your question slightly. Political party membership, I think it really depends. Once again, for me, it depends on what the impact of that will be for perceptions of impartiality and independence of the judiciary. In some political cultures, a membership of a political party is not going to be so, is not going to be seen as branding the judicial officer as immediately partisan. If there are many political parties, if there's a change in parties in government regularly, I still don't think it's a good idea, but I think one could maybe argue that in such a context, it will be acceptable. In other contexts, where membership of a political party already signals to everybody in society where you stand on so many things. You know, if you know that Judge Kavanaugh in the US Supreme Court, he's a right-wing Republican, and we all know that. I don't think in that context, I think it's a bad thing. You didn't even have to be a member of that party. In the South African context, or in Zimbabwe, or wherever where the party politics are extremely politicized and extremely polarized, I don't think it would be acceptable for a judge or judicial officer to be a member of a political party, because it will have an impact on the legitimacy of that judge and the judgments made by that judge, and ultimately on the judicial and the judiciary as a whole. But that might be different depending on a different political context.
Thank you very much, Pierre, for being so brief and attempting to respond to those difficult questions. Next question is directed to Justice Dingake. And of course, you are also free to weigh in on the other questions that have been responded to by Pierre. The question is, when judges are prevented from reading their dissenting judgments, as happened in Uganda recently, is that just an attack on free expression or independence? You are muted, Judge. You have to pick up your virtual mouth. Thank you.
Okay, you can hear me now.
I can hear you clearly.
Well, if the Professor Pierre can be so circumspect, for a judge is going to be worse. In response to that question, Justice. But let me just say this. As a general principle, I do not want to weigh into the Ugandan situation. I don't know the factual, there is a lot that I don't know, so I'll not attempt to weigh into the Ugandan situation. I'll be happy to state a principle. The whole idea or concept or doctrine of the independence of the judiciary encapsulates, as we all know, two tenets: the independence of the judiciary as an institution and the independence of the individual judge to decide a matter in accordance with his or her understanding of the law and the facts. And if that particular judge does not agree with the majority of his or her colleagues, he is totally free to dissent. And no entity, no authority has any power to interfere with the delivery of a dissenting judgment. I think that is incontrovertible. And I think we judges ought to give effect to that. So that is my answer to your question, Justice. Thank you.
Thank you very much, Justice Dingake, for weighing in on that again.
I may say on the other questions that you had posed to Pierre on foreign policy and on membership of political parties. I think he did correctly talk about some differences that may be occasioned by political cultures. I remember reading that in one country in Europe, I don't know if it's Germany or wherever, where they were saying a judge may be a member of a political party. A bit shocked because I'm a product of particular political culture and circumstances. I think the bottom line would have to be whether a reasonable, well-informed person in context of Botswana, the situation was about Botswana, would consider that such a judge may be belonging to a political party be biased such that he can't bring an objective mind to bear upon a dispute serving before him. If the answer to the question is yes, then that membership will be problematic. I emphasize that it will depend on the circumstances of each jurisdiction, and I accept that there may be in some a situation where that is that should not have a bearing, and not be so in some parts of the country. But I think it's safe for a reasonable, well-informed person form the view that such a judge would not bring to bear an objective disposition to a matter before him or her. And if the answer is yes, then such membership would be problematic. Thank you.
Thanks very much, Judge, for that response. The next is a comment, and when panelists come in, they may want to respond to that comment, or the audience, you might also post questions. So the comment is, open court, I am wondering whether it is true that disciplining judges necessarily undermines their standing. True, it will undermine the standing of the particular judge being disciplined, unless, of course, he or she reacts graciously. But it will also promote the standing of the judiciary per se. It is important that the people see that the judiciary is being held accountable to high standards too, close quote. So that was one of the, the comment from one of the participants. Let me direct this question to, well, this question is actually directed to Jill, Professor Jill. The question is, the immediate former Chief Justice of Kenya publicly complained about the judiciary being undermined by the executive. He complained that the welfare of judges is not adequately taken care of. Do these expressions fall within the permitted scope of freedom of expression for judges and judicial officers? So you may weigh in on that question, and if you want to also weigh in on the comment that I have read, you may do so. Over to you, Prof. Jill.
Yes, the former Chief Justice was very outspoken about relations between the judiciary and the executive. And I have to say that I sort of regretted that rather than restricting his comments to the attitude, the general attitude of the executive was, and indeed sometimes specifically of the president to the judiciary, he sort of expanded his remarks, particularly on one occasion, to, although you could see his point that he was saying that the judiciary is not treated with sufficient respect, it came across as looking, well, you know, you're complaining about the fact that you were received and not properly received at a big state function. You're complaining that other people have a bigger Mercedes than you have. It just doesn't come across as quite on the same level. And I personally felt that maybe he was a little unwise. But I don't think, I wouldn't have said it went to the point of being impermissible. Because there is that area in which, you know, between the thoroughly justified and the thoroughly unjustified, and the situation in which people might have a different view. But my own view, I think, went along with the questioner a bit. I slightly regretted it because I think it distracted from the main issue, even if I think with his implication that this is a sort of symptom of the same attitude. And then, now, sorry, Justice, having had the comment in my mind, it's now completely gone. Obviously, sign of old age.
Yeah, I can just repeat it. The question was, I mean, the comment was, I'm wondering whether it is true that disciplining judges necessarily.
Yeah. Okay. Now I remember. Fine. Yes. Again, I'm rather inclined to agree. It should not really be an objection to disciplining judges. That somehow it would lower the judiciary in the estimation of right-thinking members of the public, if you like. Of course, and there are ways of disciplining. Should be ways, perhaps, of disciplining judges, which are not too, and there traditionally have been ways of, as I said it myself, of quiet words behind the scenes, perhaps indicating to a judge that behavior has been a bit improper. But if behavior is serious enough to merit formal disciplinary action, then I don't think it, on the whole, would lower the judiciary in the estimation of the public, or the respect that the public have for the judiciary. Unless, of course, it was happening so often that it tarnished the entire judiciary, in which case there's something wrong with the entire judiciary. So I rather, again, agree with the commentator on that.
Thank you, Prof. The next question is going to put Radmila on the Justice Dicic on the spotlight, but it also brings back Pierre onto the virtual podium. So the question is, would the Chief Justice in South Africa have been immune had he made his statements on Israel within a court judgment in Obiter or in Obiter? And maybe for the benefit of Justice Dicic, really, the Chief Justice of South Africa made some comments about South Africa's foreign policy towards Israel and criticized the foreign policy position. So I think the question is, would such statements, would the Chief Justice have been within the confines of freedom of expression if he had made his statements within a court judgment or in Obiter? So that's a question for Justice Dicic, and the people want also Pierre to weigh in on that, the people who asked that question. So let's have Justice Dicic first, and then Pierre second. And Justice Dicic, as you address that question, can you also weigh in on the question regarding political party membership? I think the question was to try and balance between freedom of association and expression for judges and maintaining the perception, maintaining judicial impartiality and independence. The middle, judges can be members of political parties, active, or they don't have a functional role in the political party business. So the person who posed this question wants to know what your views are. So
okay.
Yes.
Okay, I got this one, the second part, but somehow I didn't understand that the first part of your question or whatever was for me. But anyway, you will add it later if necessary. But I just wanted to say that mainly the most of the constitutions in the countries in Europe, and especially Eastern Europe and the region, are forbidden judges to be the members of the political parties, which I agree with. And then it doesn't say anything about political activities. It is then maybe can be taken out from the code for judges. But then it is interesting just that in Germany, by their code, judge may be a member of political party, but then it says a judge should not mention his or her office when he or she expresses political opinions in public, except with respect to legal questions. So it's really hard, like in countries like, I don't know, like Serbia, Hungary, Poland, or it's small. I mean, they're big countries, but Serbia is smaller. But anyway, judges somehow are well known, especially Supreme Court judges, and it's hard to hide whether you are the member of a political party or not. So for me, it's the best that there's no possibility for judges to be members of political party because it's very hard to draw the line in the activities, and that's what they are trying to say in the messages they are trying to spread. But I think that there's another danger. So, okay, we're not the members of political parties, but what is done in countries in this part of the world, they are still struggling with this good division, with the democracy. Everything is political, you know. Even if we say something about vaccine, whether we have not that political. If we say, I don't know, whatever, everything is political. So in any case, whatever judges say may be treated as political. So it's a danger that is always over our heads, that's always behind the attacks on us, that we are somehow acting as a politicals, acting in front of opposition. But I don't care for that really, and some of my colleagues, we don't care, and that is why I think it's good that we are not the members of the party. Then we can fight that everything what we are saying we are doing for the good of the citizens. And I think that the role of the judges is also to educate the citizens, to bring this sense of the rule of law in the countries, because the people are so confused, because in my country, in other countries in the region, the executives, they are saying things, they are dealing with the investigations on TVs, they are bringing the proofs, they are breaking the presumption of innocence, whatever, contradictory trials. And so we have to go out and tell this is forbidden to the citizens. And they are making, with their statements, they are making the citizens to believe that judges are under the political influence. If our high prominent politicians come and say that those people will be, then citizens believe that we bring our decisions under this influence. So we have to act, and I don't think it's, even if we are disciplinary or whatever in Serbia or wherever, I think that those judges can, if they are acting right, in a good faith, and is considering by the majority of judges, they are defenders of the independency and impartiality of judges and the rule of law. And what was else? Did I say what you wanted, or did I miss something?
Yes, that's the question I had posed to you. I think the other one is more relevant to Pierre. So thank you very much, Judge. Pierre, do you want me to repeat the question, or?
No, I think I understand the question. It's an interesting question. So it's an interesting question because the code in South Africa, well, the Judicial Service Commission Act firstly says that you cannot complain about a judge because you disagree with the merits of a judgment or the order that is. If you look at the code, so if the judge disagree with, even if part of the reasoning, it's going to be, I don't think that is going to amount to the kind of things that in our system would amount to judicial misconduct. So, and also the code itself seems to suggest that if you make comments that otherwise will be perceived as being politically controversial, but you express it in terms of specific legal principles, that is probably not going to be frowned on. So I think if the South African Chief Justice had said, nice to Israel, people would have been cross, and some people will be cross because this is a very actual topic, but I don't think the Judicial Conduct Commission committee would have found against the Chief Justice, which brings us to the point I made right at the beginning, that sometimes with these kind of things, it is not one says, but how one says it. So sometimes the way in which one's views might be expressed as a judicial officer might make them sound less judicial, make them sound more partisan, and that's a problem. In South Africa, we have a very well-known judge, also is one of my colleagues at UCT, Judge Dennis Davis, and he has his own TV program. Well, he had his own TV program and he's going to get another one in which every week he would discuss something controversial that is part of the political system. He's never been complained about because the way he does it is he expresses a kind of openness and maybe, I don't know for what other reasons, but for me, it's very interesting that sometimes how one expresses one's opinions, what forum one uses, might influence how the public will perceive one and will perceive whether you are impartial or not, and that might play a role, and it should play a role, I think, substantive.
Thanks, Pierre, for that. I'm going to pose the last question in the interest of time. So the last question is for Professor Dingake, but it also brings Pierre back, so it's not yet time to rest, Pierre. I will have Judge Dingake coming first. So the question is, I quote, "The cases from Europe referred to by Justice Dicic highlight the notion of protection of judges from executive or legislative overreach, and there is extensive jurisdiction developed around these issues. Professor De Vos suggested that in assessing the limits on judges' freedom of expression, the intention underlining the limitations should be ascertained. In Europe, the European Court of Human Rights, which has developed so much jurisprudence on this question, can serve as a neutral regional arbiter of this intent. But what can be done in other regions where similar regional tribunals don't exist with as binding authority as the European Court, and where the jurisprudence on these issues is limited?" So over to you, Professor Dingake, and then I think Pierre can...
I can't get the question. Get the question, Justice?
I think the question
What is the question?
Europe, let me read the last part. In Europe, the European Court can serve as a neutral regional arbiter on these issues. But what can be done in other regions where similar regional tribunals don't exist with as binding authority as the European Court, and where the jurisprudence on these issues is still limited?
Well, I'm not sure. I'm sure maybe the professor will answer it better than me. I don't seem to get the nub of it. But one may just say that earlier I said, if you bring the issues of moment back home, in my mind, what would be very critical and primarily critical would be the baseline constitutional that determine those issues. In other words, the text and spirit of a particular constitutional provision will be critical. But what I do notice is that, say for South Africa and maybe a few other countries aware of, the judicial code of conduct that may be in existence authorized by an act of parliament, many countries don't have, or those that have, they do not have elaborate provisions similar to the South Africans ones. And but to the extent that you mentioned the European Court of Justice and the regional arbiter, you know that in our part of the world, regional courts, at least in Southern Africa, one of them was killed and subsequently resurrected, but with a more constrained jurisdiction. But I would say that the answer does not necessarily lie in a regional court per se. It relies in sharpening the legislative framework even in individual countries, to be alive to some of the issues that we are discussing today, so that you do not necessarily, if the legislative framework is sufficiently developed, you may not necessarily need a regional bloc or a regional supranational court to act as the safeguard. Thank you.
Thank you, Justice Dingake. Pierre, do you want to weigh in, or?
I would say two very quick points. The first one is, I think that one mustn't underestimate the power of the judicial culture. So some of the limits are actually, it's just as much about the judicial officers themselves feeling that the judiciary is an important institution and acting in accordance with that. So that's the first thing. I don't know what would happen if you don't have a regional body, but I would say the following: the one precondition, I think, to ensure judicial independence is maintained and to ensure that allegations of improper expression is not used by the powerful to try and muzzle judges, is that judicial officers should be play the dominant role in any kind of interpretation of the code and enforcement of the code. If you don't have a majority of judicial officers making that judgment about what the code means and whether it has been infringed, any system of discipline can easily be used to try and muzzle judges, to intimidate judges, and thereby limiting the independence of the judiciary.
Thanks, Pierre.
And on that last statement, Pierre took us to the other comment, Justice, that you had floated earlier about one of the participants wondering whether it is that disciplining of judges undermines the independence of judges because it may promote accountability of the judiciary. It dovetails nicely into that. We must understand the two pillar principles are critical. The independence of the judiciary is absolutely critical, and so is the accountability of the judiciary. So the judiciary should be accountable, but disciplinary processes should not be manipulated to undermine the independence of the judiciary. I think that is very important. In sub-Saharan Africa and maybe some other countries, that is not uncommon. So that balance is always important, and usually there is a tension between judicial independence and accountability. Both of them are critically important and should be promoted.
Thank you very much, Justice Dingake, for that intervention. I will use my discretion as the chair for this session to pose one last question. And I would like to call on to the virtual podium to call back Justice Dicic and Professor Jill Guy. The question is, can judges be active on social media in their personal capacities? If a judge engages on social media under the limitations mentioned of academic comment or comments on their judgments, could this still be construed as operating in a political landscape? I think the question becomes a little bit muzzled, vague at the end, but I think the main part of that question is, can judges be active on social media in their personal capacities? We can have Justice Dicic first, and then Professor Jill closes.
Okay, thank you. Talking about myself, I'm not active on social media because, in a way, I'm afraid of that. I'm judged in criminal affair, organized crime, top crimes in Serbia, and so I'm not so good in all those new social media, and I'm afraid that I'll be somehow whatever by something followed by someone and whatever. And I think that if judges are good in that, they can be, but there's the dangers which I faced it also. I was at some place, at some parties, restaurants, whatever, and I could see other people taking pictures of me, and then we always have to be aware of, you know, that we are judges, have to take care about our dignity, whatever, and that if we are seen in public, and there are very often now also in Serbia and in the region, in Croatia, with pictures of some judges with some people that are kind of criminal people from the criminal background. Whether they are somehow fake pictures or not, it's really, I don't know. For me as a judge, it's dangerous. But there are some younger judges that use social media. They have their own blogs. They talk with the people and they do it well. And I think that United Nations delivers some manual for judges and social media, and what are the rules, what is to be taken care about. And I think it's good, and also some European institutions, and I think the American CILI organization also issued a good manual. It's seated in Prague, which is somehow good and practical. So that's what I can say about that. I'm old-fashioned.
Thank you very much, Vice President Radmila. Over to you, Prof. Jill.
I think it's hard for judges to be usefully engaged on social media. Both our current Chief Justice recently retired and William Mutunga before him, both of them were on Twitter, indeed still are. I found that the second Chief Justice used it very cautiously, didn't really talk about cases, talked about his role as Chief Justice, which seemed quite legitimate. And on the other hand, it's not terribly exciting stuff. And for many, I'm not sure many people get away with the sort of, judges get away with the sort of thing that Dennis Davis apparently does in South Africa. It would be very hard, I think, for judges to comment in any form, social media or otherwise, on their own judgments. Because the thing about a judgment is that it's a reasoned affair, should be a reasoned affair. Let other people comment on your judgment, let other people even explain your judgment. But if you start to explain your own judgments in a way different from what you did on the court, you're immediately going to run the risk of people pointing out differences or wondering why you're doing it, or are you doing it to be disagreeable to other judges or something. I think, although in principle there doesn't seem to be anything objectionable about a judge just because a person is a judge being on social media, and indeed the Kenyan code of practice indicates that, I think that it must be very hard unless you want to, if you want to comment on football or something, then that's fine. But if you want to talk about law, you're going to run into quite difficult situations, either because you're talking about what's already happened, or because you run the risk of talking about something you might actually get in the future.
Thank you very much, Prof. Jill, for sharing that perspective. Colleagues, ladies and gentlemen, I believe maybe that I've tried to do justice to your questions and your comments, but because of time limitations, we can't go on and on and on. So at this juncture, I would like to hand over to our Legal and Communications Officer, Tanvia, so that she can give closing remarks.
Thank you so much, Justice. And I'd like to take the time to thank everyone involved for their contributions. I really believe that this webinar was extremely enlightening. And if I could summarize it in 2 bullet points, really, I think it would be what Professor De Vos hammered home back during our constitutional law classes, that it's always going to be probably a case-by-case basis and a balancing exercise. And the second bullet point was, if you want to be a judge, probably don't get social media unless you're going to comment about soccer. So other than that, I'd like to extend a personal thank you you, and also our thanks on behalf of ICJ's Center for Independence of Judges and Lawyers to our esteemed panelists, to the commissioners who have honored us with their presence today, to our participants who have contributed extremely, really well in the comment section with their questions, and our partners as well. And just as a final note, we'd like to remind everyone present to maybe keep an eye on our social media for the future events that the Center for Independence of Judges and Lawyers would like to hold as well. I think it would be just as interesting and enlightening as this event. And our Twitter is @ICJARP, and our Facebook page, you can find it at ICJ Africa. Thank you everyone involved. And again, a big thank you to our esteemed panelists for today. Goodbye, everyone. Thanks again.
Goodbye, Tanvir. Thank you.
Goodbye. Thank you. It was excellent.